This is Colin O'Keefe for LXBN TV. Last month, the Court of Appeals for the D.C. Circuit ruled that President Obama's recess appointments to the NLRB were unconstitutional. As CFPB Director Richard Cordray was appointed under similar circumstances, many have wondered about his and the CFPB's future. Joining me to discuss is Keith Fisher of Ballard, Spahr, and the CFPB Monitor. Keith, does the Noel Canning decision have an immediate impact on Richard Cordray and the CFPB?
Good morning, Colin. I don't think it has an immediate direct impact because, of course, by its nature, this decision only applies to the appointees to the National Labor Relations Board. And there is no court decision out there that calls into question the validity of Mr. Cordray's appointment. However, the rationale of the D.C. Circuit's decision in Canning can be applied equally to the recess appointment made on the very same day by President Obama of Mr. Cordray. And what that does is it casts something of a shadow onto the agency as a whole and the validity of a lot of the actions that have been taken during the past year under Mr. Cordray's leadership. These include, of course, a number of regulations that have been promulgated, some enforcement actions that have been taken, some investigations that have been begun, all under the authority of Mr. Cordray as the director. And if that authority is invalid, that in turn creates some doubt about the efficacy of these other actions. So it could be quite chaotic unless, so the government should be thinking about contingency plans. And obviously because of that, I think also that the government will want to take some kind of action to seek review of the Canning decision because of these implications, and also because of the chaos it causes at the NLRB, which has lots of orders outstanding during that same 12-month period and no quorum if the Canning decision is correct. So their options, as you know, are to seek rehearing or rehearing en banc from the D.C. Circuit, or to petition for certiorari to the Supreme Court, or to do both of those things. But I don't think, with the possible exception of rehearing en banc, that you're going to get a decision on that anytime soon.
Absolutely, absolutely. Have you seen or do you expect efforts to temporarily curb the CFPB's authority while the controversy of Cordray's nomination is resolved?
Well, there are two court cases already of which I'm aware, both of which antedate the Canning decision. One is the fairly well-known National Bank of Big Spring, Texas case, which was filed as a much broader challenge to the constitutionality of a lot of things in Dodd-Frank. And only one piece of that is the recess appointment of Mr. Cordray. We have previously talked about that in the blog, and I think, and many people think also, that there is a serious problem with standing of the litigants in that case in general, and in particular with respect to the Cordray appointment. There's another case that was actually initiated by the Bureau against a lawyer and a law firm in California. And this case was filed in July of 2012 against this law firm. It's CFPB versus Chance Edward Gordon et al. And the government obtained a preliminary injunction against the law firm and an asset freeze and imposing a receivership on the law firm as recently as November 16th, 2012. In an answer to the complaint, the lawyers raised the invalidity of Mr. Cordray's appointment as casting doubt on their ability to even bring that action against the defendants. And furthermore, since the Canning decision, I understand that the lawyers have written to the government and basically said, look, if you don't withdraw this case, then we're going to file a motion and we're going to argue that the receivership and all that stuff has to be undone. The CFPB has no authority to act, and that would be worse for you than if you simply voluntarily withdraw. Well, the government hasn't bitten on that. As I say, they're very much taking a business as usual approach here. And so those are the two cases that are pending. Now, as I said before, if this thing drags out, for example, unless a petition for certiorari were filed fairly soon, I mean, in theory, the government has 90 days, but the Supreme Court's term ends in June. And so even if cert were granted in June, you wouldn't be able to hear the case until the October term begins next fall, right? And so you wouldn't get a decision for many, many months. If that is the situation, then I think more incentive becomes created for various people that might be subject to orders of the Bureau to say, hey, let's challenge it. And to be perfectly honest with you, Colin, if a client were to come to me today and say, I want to file a challenge to this, and I would go right to the U.S. District Court in the District of Columbia and seek a declaratory judgment and a preliminary injunction on the strength of the D.C. Circuit's decision in Canning, which the U.S. District Court would be constrained to follow as long as it's still good law. And so that it's not, and anybody else would probably choose the D.C. Circuit as the venue for such a challenge, given the strength of that decision and the strength of its logic. I think it's a very well-reasoned decision. So on the merits, it will be maybe difficult to get it overturned. But if it isn't, and the longer this plays out, then I think we might see some actual challenges.
Again, that was Keith Fisher of the CFPB Monitor. For more of his insight on the story, be sure to visit CFPBmonitor.com. And for more video interviews from LXPN TV, along with curated commentary from the LexBlog Network's thousands of authors, be sure to visit us at LXPN.com. Thanks, Keith.
Thank you, Colin. Good to be with you.